I think Your Honor can issue a subpoena, and then we can then take that to Texas and ask that it be enforced. Should another jurisdiction decide not to enforce it, that would be an issue that we have to resolve in that other area. I think the court should also consider and look at that this agency availed itself to the state of Florida when it chose to come here and transact business. When it chose to accept donations, and I believe they've even claimed to have been or open up an office here in the Central Florida area. You can't avail yourself to a jurisdiction and then claim that you can't be touched by a subpoena. I think that's Civ Pro 101.
I'm going to take a look at the cases, and I'll take this under advisement and decide it later today. I think the deal is doing business is, I don't know if that is appropriate here since they're a nonprofit and they're a Texas nonprofit. Having said that, if you have any, you make requests in your application, and again, it's not that the evidence isn't relevant. That's not really the issue here before me. So if you have any cases that support your position, get them to me by noontime, because I'll do an order on this afternoon.
Yeah, if I might be heard briefly.
Yeah, go ahead.
Thank you, Your Honor. As it relates to the lack of responsiveness, there was nothing alleged in the pleadings. One can't respond to what was never alleged in the pleadings in the first place. One cannot simply go out there and say they're an arm of the state of Florida. It's not even alleged in the pleadings. So how, in heaven's name, can anybody address something if defense doesn't even set forth the grounds? We're not mind readers here. The fact of the matter is there's a right and a wrong way to do it. This was done completely wrong. If you could even overcome that, we have other issues as far as the ability to finance it and all that, which we'll address if they can overcome the initial burden.
Get me anything else that you want to get me by noon or shortly thereafter. And if you don't prevail on the motion, it'll be denied without prejudice. You can always refile, but I'll rule on it today. But get me. You've handed me the cases I think you need.
Which are all the cases in our memorandum, Your Honor.
I'm good with that. But anything else that you're going to send me on this issue, I'd like by noon. Okay.
Thank you for your consideration.
Yes, Judge. I'd like to respond briefly and get one or other matter on the record.
On this?
Yes.
All right. Briefly.
Okay. I have a hard time believing that Mr. Nijam has not been following this case. Specifically, when we're talking about the allegations or the possibility that these may be agents of the state, and I'd like to approach the court with a exhibit, if I may, in response to one of Mr. Nijam's allegations in reference to paying. I think they addressed or criticized the defense about not paying for certain tips. Attached is an email from the lawyer, Miss Anne Marie Delahunty, from Orange County Sheriff's Office, where she admits that some of those tips were not in conformity with what we asked for and what our specific request was, which is what's been debated all along. So I just wanted that to be, should the cost issue come up. I know Mr. Nijam was not privy to that information, so perhaps that's the reason why he made those statements in his motion to strike.
You can respond to this later.
I need to respond to one other thing. If you'll allow me one brief minute. It won't take any longer than that, I promise.
Okay.
I attempted to hold back on it. I didn't think this was the appropriate forum.
I see you sat for almost 20 seconds.
Thank you. That's a record for me. Your Honor, since the defense attorney comments that one must have familiarity with it, he clearly has familiarity with the fact that I represent Texas EquiSearch. I am baffled why he was then contacting my client directly without going through me. And accordingly, I held back on that because we were wanting to find out if, in fact, he was aware that we were, in fact, representing Texas EquiSearch. Since he's obviously following it and made a suggestion that one should know, he's been in direct contact with my client without my authority, approval, or knowledge until after the fact about attempting to seek the very records which he's in court for today. His Honor is well aware of the inappropriateness of that. And so all matters should, in fact, go through counsel and not around counsel.
Having dealt with that, then we're off topic now. He's requesting the records listed in his motion, subpoena ducis tecum. I'll rule on that later today. Once again, anything that you're going to get me on that issue needs to be to me by noon. We have then...
Judge, if I apologize. I think I'm under the duty of...
Hang on. Are you still arguing the motion that we just dealt with?
Not directly, but I feel I have to respond.
Well,
to...
There's no need. None of that has any legally... I understand his point. I understand your point. My time is limited. So, again, I will consider your motion. If you have anything that you want to send me that buttresses what you said there, send it, and I'll rule this afternoon. If you want to write down anything, I'll send it to me. Again, our time here is kind of limited this morning.
I understand, Judge. As an officer of the court, I feel I do have to advise a possible violation of Rule 4-1.9 of the Canon of Ethics. Mr. Nejam represented both Cindy and George Anthony previously, and the Anthony's family had requested this information from Mr. Miller directly.
Let me stop you. You're basically sort of filing an ora tennis motion in court. He hasn't heard this. If you want to make, whether it's a bar complaint or put the court on notice regarding some ethical violation, put it on paper, send it to me. But that's not noticed for today. Okay, we're just...
What I'm just saying is, I think it's my specific duty to advise the court of that issue. I wouldn't be doing any filing of any bar complaints or anything like that.
Court's on notice. Let's go then to the next motion, which is, this will be, I think, the state's motion, Ms. Strain Burdick's motion, to strike the defense witness list, which she has attached to her motion. Let me just turn it over to her. Go ahead, Ms. Strain Burdick.
Your Honor, this motion was actually filed in December, shortly after we received a witness list that had the names of 3 experts on it, and then just a reference to the state's witness list. Under the case law, that was improper, so I did file a motion to strike. On January 22nd, it was an amended defense witness list was faxed to me that appears to be legally sufficient, and so our motion is now moot.
All right, the motion to strike is moot. You now have one that's correct under the rules, and so there's nothing else that needs to be said there, which gets us to our final motion this morning. And then if we have a second, we can talk about perhaps a status date and see where we are. This would be the emergency motion to recuse filed by Ms. Bodden. Why don't you go ahead?
Yes, thank you, Your Honor.
And the
Good morning,
motion
sir.
to recuse goes to the state attorney, correct? That's who you're trying to recuse.
Good morning, sir.
Good morning. Go ahead.
Your Honor has taken great pains to make sure that both the state and the people of the state of Florida who have a vested interest in this case, along with our client, Casey Anthony, who has obviously a vested interest, all rights are protected on both parts. Your Honor, as you know, has required Ms. Anthony to be here in court on the basis that should a conviction be obtained by the state, Your Honor did not want any appealable issues that were just flagged out there that could overturn such a conviction. Likewise, Your Honor, obviously has been and has the duty, and we trust, Your Honor, because you do wear the robes, to protect all of the interests of our client, Ms. Anthony, when it comes to the basic fundamental rights of the right to the fair trial and the right to representation of her Sixth Amendment right to counsel. Now, we have filed this motion asking, Your Honor, to ask the prosecutor to voluntarily recuse themselves or whatever persons in the office this may be applicable to because of an incident that arose that we became aware of. Again, as we become aware of many things in this case through the media. The other day there was a media report filed, and we put that in our papers, concerning the fact that at least one of the complaints before the board, the ethics board, was filed by someone. And we do not know who, because it's kind of like a Kafkaesque trial situation. Allegedly they were supposed to be anonymous, but apparently the agency responsible for that did confirm to the media that the state's attorney's office, someone, had filed a complaint against Mr. Baez, allegedly for the statements made against the state's prosecutor, Lawson Lamar. I would note today, for Your Honor, and I did confirm this myself last night, with
We've been listening in on a court hearing in the case against Casey Anthony. You see her there in court. It's still going on. We're going to take a quick break, though.
Live streaming continues at WESH.com. We'll be right back.